Good afternoon, and thank you all for joining us for the latest webinar from the American Bar Association's Civil Rights and Social Justice section, brought to you by our Education Committee. I bring greetings from our section chair, Wendy Mariner, and the Education Committee co-chairs, Christy Susie and Cynthia Swan, and special advisor, Beth Wittenberry. Thanks also to Jerry Gardner, our section director. I'm Janelle George. I'm also a co-chair of the Education Committee, but today I'm speaking in my personal capacity. I would also like to thank the sponsoring ABA entities, the Division for Public Education, the Standing Committee on Election Law, the Center for Public Interest Law, the Center on Children in the Law, the African American Affairs Committee, and the Section of State and Local Government Law. Please note that the views expressed herein have not been approved by the House of Delegates or the Board of Governors of the American Bar Association, and accordingly should not be construed as representing the policy of the American Bar Association. They are the views of the individuals themselves in their personal capacities. Today's webinar features scholars who will share in what today will be the first of a total of 4 webinars that launch our new series, Education and Democracy, in which we will explore how quality education can help prepare informed and engaged citizens, and how deprivation of quality education can result in marginalization from full participation in democratic institutions like voting. We will begin with an introduction of our speakers, and at the very end, we will take questions. You can ask questions of the panelists by finding the questions drop-down box in your webinar menu. We also want to note that we will be sharing a recording of this program to everyone who is registered, so please share widely with your networks. We will also provide handouts as well, along with the recording. It is now my pleasure to introduce you to what is really an esteemed panel of education scholars. You can read the more detailed bios of today's panelists in the handout attached. The handout with the bios is also in the webinar menu, and you can access that. First, Peter Cookson, Jr., who is a professor of sociology at Georgetown University and a senior researcher at the Learning Policy Institute, where he co-leads the Equitable Resources and Access team. He will begin our discussion by grounding ideas of education, access, inequality, and civic participation within the larger goals of public education. We will then hear from Lisa Holder, who heads her own firm in Los Angeles and also serves as of counsel with the Equal Justice Society. She will discuss her litigation efforts to expand access to quality education and how marginalization from educational opportunity impairs civic participation. We will then hear from Professor Kimberly Robinson from the University of Virginia School of Law, who will discuss the San Antonio Independent School District versus Rodriguez case and its implications for a federal right to education. She will also discuss the social science research on political participation in education. And finally, we will hear from Michael Rebell, who is a professor of law and educational policy at Columbia University's Teachers College, who has litigated several cases related to educational equity, including a landmark school funding case in New York and a current case involving the right to civics education in Rhode Island. So we will begin with Peter Cookson.
Great. Well, thank you so much, Janelle, and thank you, ABA, for putting on this really important series of webinars. Nothing could be more important today than the issue of education democracy. I'm going to just kind of help frame the conversation a little bit. So the question before us, I think, really is how do we prepare students for meaningful participation in democracy? Basically, my argument, if you will, is to prepare students for partnership or participating in democracy. We need democratic schools that are built from the grassroots up, and that the habits of democracy develop from the inside out. Because socialization for democracy goes all the way down. Schools themselves must be democratic all the way down. And the habits of democracy that I'd like to touch on today are compassion, freedom, reason, and cooperation. Much of this work comes from work I've done previously and so forth and so on. I won't go into that, but much of it's grounded in schools that I visited around the country with myself and with other colleagues. One thing before I get started, I would love you to think of the school that you would have liked to have gone to that gave you the space and the freedom to develop all your capacities and talents, and also to help you develop that capacity for freedom that is essential for democracy. So what kind of school would that be? And just maybe use that as a frame and see how it comports with some of the things that I'm going to be saying. Well, we start off with a little quote by Martha Nussbaum, and I think one way to frame this is very important is that the education crisis that she refers to is very, very much entangled with and part of the crisis in democracy. Democracy itself is in a moment of trial. Not to use a pun on the current events right now, but also more research shows us a lot of folks have actually lost faith with democracy, even young folks. So, and they don't know a whole lot about democracy. And 1/3 of Americans say that army rule would be preferable to democracy. So we're faced with an enormous challenge. And I believe that education can really, really resolve or help to resolve a lot of these paradoxes and difficulties. Why don't we go to the next slide? So the first one I want to really talk about is the habit of compassion. And really what we need to be able to do is to face honestly the challenges in front of us. We are living at a time of extreme income and wealth inequality. We're living at a time when racism is part of this sort of the social fabric of how we're living today. We're living at a time when there are disparities of access, not only to school, but to other resources. We're living at a time when social mobility itself is blocked, which has huge implications for how people see democracy and education. Remember that the whole premise of public education from the founders on up was that public education would provide a level playing field. It doesn't do that today. It reproduces an unlevel playing field with sometimes irresystematic consistency. And of course, we want people to be able to join in self-governance. The quote that I have from Edmund O. Wilson, I won't read it all to you because you can see it, but what he's pointing out to is we're living in a time of epochal change and a time when we're not sure what the future really holds. And therefore, education itself has to be sort of reinvented in order to embrace these times. And one of the ways that I think about how to think about that is we know from history, we know that successful societies have really had, while they differ in so many ways, have had basically certain characteristics, which are inclusive, they're tolerant, and they're cooperative. So that's the foundational idea for how education might make a difference. Why don't we go to the next slide? Now, democratic school, if we're going to cultivate democratic habits of heart, so I'm going to talk a little bit about these habits in a little bit. We need democratic schools and democratic classrooms. And one of the ways to think about that, based on what we can see out there, is that learning needs to be authentic. And authentic learning, we know from research, has certain characteristics. It's personalized, it's experiential, it's expressive, it's imaginative, it's social, and utilizes our collective intelligence. In order, Hannah Arendt, the philosopher, said that you couldn't have a democracy without the habit of freedom. So how do we get the habit of freedom? One is that I like to think of this a little bit like in Ubuntu, the African saying, I am because of you, which is a profound way of saying that we are all together, that I don't exist without you. That's a profound idea about a habit of heart that we ought to be having in our schools. Students need to be able to overcome fear and fantasy. Our society is wrapped up in a lot of fear and fantasy. And foster social attachment. And fostering social attachment means creating a school environment, and we can't go into all the details now, where there's equity, where there's joy, where people are treated equally and well, and that requires resources. It requires financial resources, human resources. We won't get to all the pieces of it, but that is how social attachment is created, and that's the seedbed of really the democratic personality, because there is a democratic personality. Sometimes if you're looking outside, just looking outside the webinar, you see that people vary on their sense of authoritarianism and how they want to settle issues. Democratic personality has certain characteristics of tolerance, forgiveness, being willing to accept the views of others, all those things that we know, but schools have got to cultivate them. In order to do that, the schools themselves have to create those, they have to walk that walk, they have to live that live. And so we have this quote from Fieri: hopeful inquiry, human beings pursue in the world, and with each other. So that sense of collective effort is key to creating this personality, this democratic personality. Why don't we go to the next slide? See that John Dewey, who really in many ways is, started this idea of democratic schooling, and I'm sure many of you know John Dewey and have read his works. But I thought this was a particularly powerful quote in a time when so much of education has become technical, technocratic, testing. We've got to move away from that. We've got to go back to the origins of how people learn. People learn all the way down and from within. So when he says knowledge is humanistic in quality, not because it's about human products in the past, because of what it does in liberating human intelligence and human sympathy, any subject matter that accomplishes this will result in humane, and any subject matter that does not accomplish not even educational. So Dewey really sees that reason comes from experience, interaction, and doing. And of course, most of you know that he thought the school and society were really the same. And so I think this is actually a very important thing to come back to, because there's so much in our society that asks people to be unreasonable, live in a fantasy world in some way. Let's go to the next slide. So finally, so what does this all lead to? Well, how does this have to do with creating a meaningful civics experience for students so that they can participate in democracy? Final habit is the habit of cooperation. And you see the quote from John Rawls, justice is fairness. If we don't treat each other as equals, if we don't learn that in school, if that isn't deeply socialized within us, if that isn't infused into our personalities, then we struggle to think in democratic ways and to have a democratic personality. And so part of what that includes, that sense of cooperation, is frankly overcoming delusions that we have about others and prejudices and all sorts of ideas about the world that are essentially inaccurate. Gaining a sense of reality, which is sort of like the reality principle, only different, a sense of reality, a sense of responsibility, and finally having an open system of thought where facts matter, where you're able to evaluate facts in a way that makes sense in a frame. So this is my thinking, and I think my time is coming close to the end of the presentation, but I think I tried to frame this into sort of going back to what would create a meaningful civics education. I don't think it's sitting in classrooms entirely and reading books. It's the transformation of schooling itself and the day-to-day interactions that really walk the walk of what it is to live in a democratic society. So I think that's it, and thank you. I appreciate it for listening.
Thank you. So next we will hear from Lisa Holder.
Thanks, Janelle, for the introduction, and it's a delight to be here with these esteemed co-panelists. I'd like to do justice to that wonderful theoretical framework that Peter just set out. By using that theoretical framework and to ground some of the work that activists and movement lawyers like myself are doing to cultivate that habit of freedom and that democratic personality. I'm going to focus my comments on California's fundamental right to education and the litigation and advocacy work that the Equal Justice Society and my firm are doing to make sure that fundamental right is viewed through an equity lens, and specifically a racial equity lens. California has a fundamental right to education, along with 22 other states. And that right has been outlined by two seminal California cases, the Serrano case and the Butt case. Now, EJS in my work seeks to make the fundamental right to education more meaningful. We do work to enhance the quality of and access to K through 12 and post-secondary education. And we believe that work drives the development of a more perfect democratic union. Quality education and enhanced citizenship requires diversity. Diversity of experience, opinions, perspectives. That's the cooperation that Peter was talking about. And that is part of cultivating the democratic personality. The diversity that I'm talking about comes from uniting students from diverse demographic backgrounds. Social scientists have proven quantitatively that diverse work and educational environments are more focused and more productive than homogeneous spaces. The studies show that racially diverse spaces are sometimes 30%, 35% more productive than homogeneous spaces. As a college and law professor, I can attest to the importance of diversity in the classroom. I can impart critical thinking skills. I can cultivate that habit of freedom and democratic personality much more effectively in an ethnically diverse classroom. Students are more apt to rise to the occasion when they are among a diverse group of peers, and they are more apt to come out the other side sharper, brighter, enlightened, and ultimately more prepared to thrive in a global workforce and in a participatory democracy when they have access to diverse classrooms. So I want to talk a little bit more concretely and in a way that's a little bit more grounded and less theoretical about how EJS and myself are trying to bring that equity lens to the fundamental right to education that we have in California. So concretely speaking, we're working to make educational environments diverse and inclusive by, number one, ending the school to prison pipeline in K through 12. And number two, by making post-secondary public education accessible to high-achieving students from disadvantaged backgrounds by eliminating the SAT and the ACT requirements. This litigation and advocacy work seeks to compel the courts and the state apparatus in California to declare that education equity is part of California Constitution's fundamental right to education. First, I want to talk to you about a case against the Kern County High School District. Kern County is in the Central Valley of California. Bakersfield is one of the counties in Kern. And the case that we brought involves California's fundamental right to education without racial bias. The California Constitution equal protection claims that we have brought against Kern County High School District were in response to alarming rates of racially disproportionate discipline. Black students in Kern County were being expelled and suspended at a rate of 3 to 4 times that of white students. Unequal and unfair discipline was essentially being used to get around Brown v. Board of Education and to resegregate the Kern School District by sending Black students to inferior educational institutions that were essentially warehousing institutions known as alternative schools. We were able to prevail in Superior Court, state court, on our equal protection claims and a host of claims brought under the Education Code in California. And we entered into a structured settlement with the Kern High School District. That settlement, I want to just sort of go through that settlement, the particulars of it, because it really gives a concrete understanding of the work that we're doing on the ground to make the education process more democratic, less biased, and to create the type of democratic schooling from the grassroots up that Peter was alluding to. So the settlement that we entered into requires that all teachers and staff and police officers in Kern high schools attend continuous counter-bias training and training in de-escalation and restorative justice practices. The settlement eliminates discretion in meting out discipline by requiring uniform procedures for discipline across all the schools in the district, in the entire district. The settlement eliminates suspension and expulsion based on amorphous categories like disorderly conduct and insubordination, because the studies show that punishment in that nondescript context is invariably deployed in a racially disparate way, especially against Black boys and Black girls. The settlement requires transparency and the collection of demographic discipline data and statistics to monitor the school's improvement. I want to just highlight that point, the point about transparency. One of the things that we try to do when we structure these settlements to eliminate bias is we focus on this issue of transparency and the collection of data on demographics. This issue of transparency is a great organizing tool to for the community to coalesce around. And that's exactly what happened in Kern County. Parents, teachers, community activists, all have been organizing around this issue of transparency since we engaged in this settlement. And in fact, tomorrow, and this is 2 years after the settlement, tomorrow there's going to be a big march in Bakersfield where parents, students, everyone is marching to ensure that the Kern County School District continues on this course of being transparent about their demographic data and about their expulsion and about eliminating bias and expulsions. So we really have created a movement on the ground. The other thing that the settlement does is that it forces the school to recruit and make efforts to recruit a more diverse teaching staff, because the studies show how important diversity is in terms of, in terms of creating momentum for students, especially students of color. I mean, the studies are outstanding. They show that if a 5th and 6th grade student has a teacher with whom they can identify racially, for students of color, they are almost 60% more likely to graduate, just because they had a Black or Latino teacher that looked like them in the 5th or 6th grade. So diversity in recruitment is a big issue. And the settlement finally, it forces the school to employ a PBIS, positive behavior intervention support informed discipline structure in lieu of a punitive discipline structure. For those of you who want to follow the case and the settlement, the case is called Sanders v. Kern. The next case that I want to talk to you about is a case that we have brought against the University of California Regents. And the Regents is the board of directors that runs the UC system, Berkeley, UCLA, and UC Davis and the other schools in the UC system. Now, the case against the UC Regents is about the right to access to higher education, and making sure that that right is equitably enforced, and making sure that the right to education in California includes access to college, especially public college. So Our case argues that the UC must eliminate the SAT and the ACT test requirement from admissions criteria because the studies show definitively that those tests are biased and that the test outcomes are almost 100% correlated with wealth and parental income and race. This violates the California Equal Protection Clause's prohibition against race and class discrimination, and it inhibits the fundamental right to education that we have in California. The UC is publicly funded, and it has a public mandate to provide post-secondary education to California's high-performing students. And the SAT has become a gatekeeper that blocks access to high-performing students of color, disabled students, and working class students. The test is bad education policy, but beyond that, under California's Constitution, it's illegal. And as this slide shows, it's one of the reasons why there's such a lack of diversity on the UC campus. Next slide. The studies have definitively shown that equity and access-oriented admissions criteria substantially increase disadvantaged applicants' likelihood of enrolling at the University of California, which in turn increases their 5-year graduation rate by 30%, and which in turn leads to higher subsequent early and mid-career California earnings. These findings show that high-quality education accessible to all is key to eliminating the racial wealth gap and a host of other intractable social ills. And the evidence justifies large-scale access-oriented admissions policies on economic mobility grounds. It shows that the state has a compelling interest on economic mobility grounds to increase access and increase equity in terms of access to higher education. And these studies definitively show that the SAT needs to be eliminated. The case against the UC Regents, for those of you who want to follow it, is called Smith v. Regents, and it's filed in Alameda County. I know I'm running out of time, so I just want to quickly summarize. The bottom line is that California needs a paradigm shift and a new vision for education. Fortunately, we have this right to education. Now we have to give it meaning, we have to give it definition, and we have to give it contour. And that is what activists like myself and EJS are doing on the ground. California in the last 4 decades, go back to the last slide, not yet. California in the last 4 decades has built 30 prisons and 1 university. 30 prisons and 1 university. That represents a grotesquely regressive, bloated public safety paradigm that puts punishment and fear over education and hope. Education is the great equalizer and the path to active citizenship. Education is liberty and the engine for a more perfect democracy that I believe is embedded in this quotation. We need a cultural paradigm shift that puts education at its center. Here in California, next slide, we are in a moment where we can make that cultural shift happen. California now has a progressive legislator, a progressive governor, and a progressive judiciary. We are using our movement lawyering skills to push this state apparatus to put an emphasis on inclusive education and to channel resources toward quality universal pre-K instruction and to building more state universities so that all hardworking students and parents in California have access to high quality pre-K through 12 and post-secondary education. The golden rule is that as California goes, so goes the nation. Our campaign seeks to compel California's state apparatus to fully embrace education equity as the pathway to enhance citizenship. And we hope once California adopts that cultural shift, it will spread throughout this nation.
Thank you so much. Thank you, Lisa. And now we will hear from Kimberly Robinson.
Thanks so much, Janelle. I'm really excited to talk about these issues today because they're so important for the future of our democracy. So I'm just going to start with a foundational understanding that relates to both of the prior presentations, which is that there's a strong correlation, research shows, between education and political participation. So research confirms that there's a relationship between better educated citizens and political participation. So the better educated someone is of any race, this is across racial demographics, the more engaged they are in our democracy, the more likely they are to vote in federal, state, and local elections. In addition, the educational inequalities that Lisa just talked about are particularly important because they lead to different levels of participation along lines of race and class in our political system. And so really our founding fathers were focused in part on ensuring that we had an educated citizenry to ensure a Republican form of government. However, when you foreclose an excellent education from many demographics and groups within the nation, then democracy begins to break down and you don't have the ability to have an effective democracy because those who are able and allowed to participate in the democratic institutions don't have the educational skills to participate. So education, high quality education, encourages a commitment to and a capacity for deliberating on issues on the ballot, serving on a jury, exercising your right to vote, serving in public office, and serving in the armed forces. So I'm going to talk about a case called San Antonio Independent School District versus Rodriguez that held that there is no federal right to education. And I'm going to explain the connection to education and democracy as I describe the case. So in a 5-4 decision in 1973, the United States Supreme Court held that education is not one of our fundamental rights under the United States Constitution. I've talked about this case across the country, and I find that people are often surprised that they don't have a federally protected right to education. So what the court held is that wealth is not a suspect class since it was not going to apply the most exacting judicial scrutiny to it, to the disparities that the plaintiffs noted. In addition, it held that education is neither explicitly nor implicitly protected under the federal Constitution. And this was in response to a challenge brought by largely Mexican-American families who are alleging disparities in funding between districts within the state of Texas. So the plaintiffs argue something very central to our topic today, which is that education is fundamental to the exercise of effective First Amendment freedoms, such as the intelligent use of the right to free speech and the right to vote. And the court, next slide, rejected that argument and said, yes, we have protected the right to free speech and to vote. However, the court noted that it is never presumed to possess the ability or the authority to guarantee the most effective speech or the most informed electoral choice. And so the court says we recognize that there is a nexus between education and First Amendment freedoms and the right to vote. However, it was not willing to recognize education as a fundamental right because of that close nexus. The court then explains that because education is not a fundamental right, it will apply rational basis review to these educational disparities. And it gives 3 reasons for this very deferential judicial review. Next slide. First, the court says it lacked expertise on issues of local raising and distributions of funds. So to understand school funding, you have to understand that 3 sources typically fund schools. You have state funding, usually a foundation program, that guarantees a set amount to schools. Then you have local funding, which overwhelmingly in the United States is raised through property taxes. And then you also have federal funding, which ranges between 8 and 10% of education funding historically. And one of the key things that the plaintiffs noted was that the disparities in wealth between the districts led to large disparities in the amount that they could raise in property taxes, and thus large disparities in the amount of total funding that they had for their schools. And these funding disparities translate to tangible differences in the schools: facilities, curriculum, course offering, teacher quality. And the court noted that in this focus on and criticism of using property taxes to fund schools, that it was not an expert to second guess what the locality and school district was doing with those funds. Next slide. In addition, the court notes that it is not an expert on education. And it notes that there are deeply contested issues in the case, including what are the aims of education and does money matter and influence educational outcomes. So the court says we are not the one who should be deciding these issues because we're not experts in education. And so again, rational basis review is appropriate. And then finally, next slide, the court also noted that it did not want to upset the balance of federalism. Go back. It did not want to upset the balance of federalism in education. It said the case had large implications for how the balance of power is allocated between the federal government and the state government because education is largely a state function. And if the court had decided to intervene, it would have a substantial role in how schools are funded. And so the court said, we don't want to upset that balance of education federalism. And so this is why rational basis review, or this very deferential type of review, is appropriate. The court then applied that very deferential type of review, rational basis, and held that the Texas system for funding schools is reasonably related to the important tradition of local control. And the court said that it noted that local control is important to many communities in the United States, and it had endured even though there had been a centralization of funding at the state level in many states. Next slide. So the court notes that there is a consistent and kind of long-standing attachment to local control schools, and that Texans could decide that having local control, even when different communities clearly exercise different levels of local control, was a permissible goal. The court also noted that this inequality in local control was permissible under rational basis review. The court, however, did not give its approval to the Texas school funding system. It said that states, including Texas, may have relied on the local property tax for far too long, and that greater quality and equality in education was needed. However, next slide, the court notes that these solutions to these concerns about the property tax, about inequality, about the quality of schools should be decided by lawmakers rather than the court itself. And so why is this case relevant today? It's important because it has a substantial impact on how we can address the very disparities that Lisa mentioned and that her organization is admirably litigating. So, and the ones that she named and identified are not unique to California. Across the country, we have substantial disparities in educational opportunity. They lie along lines of race and class. They are in plain view and they are long-standing. And we tolerate these generation after generation. And so what Rodriguez did was drove litigation about these disparities into state court, where they have largely remained until the last few years ago or so, as Michael Rebell is going to talk about soon. So the plaintiffs there made an equity argument, arguing about disparities in funding. However, they did not foreclose an adequacy argument. Next slide. So what the court said in Rodriguez is that there is no charge that could be made that the system didn't provide the basic skills to ensure that children could exercise their right to free speech and their right to fully participate in the political process, because this argument was not made by the plaintiffs in Rodriguez. However, in state litigation in court, and more recently in federal court, plaintiffs are beginning to make just this argument and have successfully made this argument that children are not being provided what they need to exercise their rights to free speech and to vote. And finally, what's important for this case is that the court said that it is relying on state legislatures to remedy the disparities that it saw before the court. However, what we see in the litigation that has occurred is that there has been some improvement and reduction in disparities in educational opportunity. However, a large educational opportunity gap remains along lines of race and class. So there has been some improvement. We would be far worse off without the litigation that has happened, but that improvement has not been enough to guarantee all children equitable access to an excellent education. And so, next slide. If you look at the data, what you will see is that this is a report. I recognize the typeset is a little bit small, but there's kind of 3 points and they run along the middle of the graphic. So this is a report put out by the Education Law Center from New Jersey each year. And the report looks at how funding is distributed. And what we find long after, decades after the Rodriguez decision, is that 15 states are regressive. That means that they give less funding to high poverty districts. Why does this matter? This is troubling because research overwhelmingly shows that low income districts need substantially more resources to compete with their more affluent peers. But what we see is that states, and in this report it shows 15 states, give at least 5% less or more less to high poverty districts. And so they're operating a system that is not grounded in what the research has a strong consensus about. What we also see is that many states are giving the same funding, so flat funding, to high poverty and low poverty districts. Why is this a concern? It might seem initially on face value, well, equal funding is a good idea. However, when the research shows that children in high poverty districts need far more, then what you see is that these districts are setting up these states are setting up these districts and the children and families in these districts for failure by giving them the same as their wealthier peers are given. Finally, we do see some states that are progressive in funding. So in the report, there are 17 states that are flat, 17 are progressive. I will say the report has a very generous measure of what is progressive because it says if you're 5% or more, it categorizes you as progressive. But here there are 17 states that give at least 5% or more to high poverty districts. So these are states that are at least beginning, and some states who are substantially recognizing that high poverty districts need more funding. But what you see with the regressive and flat lines together is that we have well over a majority of the states are not setting up our high poverty communities for success. And the difficulty with that, of course, is that they will then lack the ability to compete for jobs, to compete for access to college, and to be prepared to engage in the political process and win on the political stage to get their interests protected, because they will lack the means and education to be able to compete successfully. And so this is one of the reasons, next slide, that I undertook this recent book about a federal right to education. And the book examines the fact that there is not currently a right to education given the Rodriguez case. And it examines 3 questions about a federal right to education. Why should the United States consider adopting a federal right to education, as well as it also has a chapter about why we may not want to consider it. Second, if we are going to recognize such a right, how might we acknowledge it? And then finally, what should such a right guarantee? So the book has chapters from experts across the country who look at these questions and consider how a federal right to education might help the nation move forward, including how it might help to address the need for an educated citizenry. So with that, I will yield it to Michael.
Okay, thanks very much, Kimberly. And I really appreciate the basis on which Kimberly really laid out the issues in the Rodriguez case and the basic problem of inequity in funding and education that was at the core of Rodriguez. What I'd like to do is talk about the follow-up to Rodriguez and discuss for a few minutes what actually has happened in all these state litigations. And then I want to talk about a new litigation that we initiated last year in the state of Rhode Island, in the Rhode Island Federal District Court, basically to try to reopen Rodriguez and get the Supreme Court to reconsider some of those key issues that they had either decided or had left open back in 1973. So first on the state court litigations, as Kimberly clearly laid out, the Supreme Court stated quite explicitly in the Rodriguez case that plaintiffs who might have a claim of inequity in funding, and as you could see from that chart from the Education Law Center, even today, a lot of plaintiffs would have very solid facts about inequities in education. But the doors to the federal courthouse essentially were closed by Rodriguez. For all the reasons Kimberly said, they made clear that the federal courts were not going to entertain these cases. So the only option for advocates, for attorneys who wanted to bring these cases, was to go to the state courts. And at the time, we're talking about the mid to late 70s, those attorneys, by and large, were very pessimistic about what the likelihood of success might be in the state courts, because quite frankly, the federal courts at the time were much more active in civil rights issues. One of the strategies that lawyers typically undertook in those days, if you had a civil rights case, was to try to get your case into federal court, because they were much more open. The precedents were better. Some say the judges were smarter. The courts had more resources, whatever. So there was not much expectation that success would come at the state level. That prediction, however, has not proved true, because the state courts have been incredibly active in this area of equity and funding in education. Since Rodriguez, over the last 47 years, we've actually had litigations in 47 out of the 50 states. And over that time period, plaintiffs have won about 60% of those cases, which is extraordinary when you think back about what the expectations were at the start. The first of the major cases to be decided after Rodriguez was, in fact, the Serrano case that I think Lisa mentioned, which established education as a fundamental right in the state of California. And the issue in Rodriguez was deciding right after Rodriguez from the federal court, the U.S. Supreme Court has just said education is not a fundamental interest under the U.S. Constitution. Does that mean plaintiffs lose? And the California Supreme Court said very directly and very clearly, well, the U.S. Supreme Court can decide what they want to decide as far as the federal Constitution. I think the court's calling. They're upset with what I'm saying here. Anyhow, the U.S. Supreme Court can decide what they would like as far as interpreting the federal Constitution, but we have the right and responsibility as the highest court in the state of California to interpret the state Constitution. So if the U.S. Supreme Court says education is not a fundamental interest under the U.S. Constitution, we're now saying it is a fundamental interest under the California Constitution. So the court really asserted its independence, its separation from the U.S. Supreme Court. As Lisa said, 21 other courts have similarly held that education clearly is a fundamental right under their state constitutions. Many of the other state courts that have decided in plaintiffs' favor have not necessarily used fundamental interest language. Actually, in the last couple of decades, most of these cases have been decided in terms of what's known as adequacy, which is not necessarily based on equal protection. It's usually based on language in the state constitutions, which the courts have held in many of these cases do entitle people to a right to education under the wording. And the wording varies from state to state, but it's things like there's a right to a thorough and efficient education in New Jersey and Kentucky. There's a right to a sound basic education in New York and North Carolina. There's a right to an ample education in the state of Washington, et cetera, et cetera. Interpreting that language, many of these courts really have gone back to the original understanding of the founders who wrote these words. Most of this language comes from the 19th century. In the New England states, it actually comes from the 18th century. The Massachusetts Supreme Court was interpreting language that John Adams wrote in the 1780s and is still in the Constitution. But what they did is update these. And they said, as Kimberly was indicating, the founders understood that education was critically important if the Republic were going to survive. We have a unique experiment, that's the way they saw it at the time, and it still is to some extent, a unique experiment in mass democracy that the American Republic was founding. And John Adams and Ben Franklin and George Washington, they all understood that if this republic was going to actually survive, and let alone thrive, the voters particularly had to be well educated, or had to at least have a basic education, and to participate in the society, they needed that education. So many of the courts are built on this, and it's led to this successful overall percentage. But what I want to hone in on at this point is plaintiffs have been successful in 60% of the cases. What about the other 40% of the states? And also, quite frankly, even among the 60%, you don't always get full compliance. So it's a very mixed bag that leaves it to the accident, however you want to term it, of where you happen to live. A child who's going to school in Chicago today is having about 60% the amount of money spent on him or her than a child going to New York City, going to school in New York City. And I don't claim it's a total explanation, but part of that explanation is that we won our case in New York, and they tried 3 times in Illinois and they lost their case. So there's no pressure in Illinois, no legal pressure, no constitutional pressure to provide adequate funding. There is that pressure in New York, and we've gotten substantial increases. We don't think we've gotten everything we're entitled to, but we have a constitutional basis for pushing for more. Well, now let's look back at what the Supreme Court was saying in 1973 about the inequities in education. They said it's not explicitly or implicitly written into the federal Constitution. Leave it to the states. Courts should not get involved in educational policy matters, as Kimberly was saying. But what this history of 47 years of extensive state court litigation has shown us is when the courts do get involved in educational policy in areas like this, they can do a very good job. And many of those courts in the 60% of the states where plaintiffs have won have come up with really workable remedies, have not interfered unduly with the prerogatives of the other branches. They've answered a lot of these concerns that the Supreme Court had. In any event, we decided a couple of years ago that if we're going to solve the overall problem of inequity in funding, as Kimberly very well pointed out, the inequities persist, and they persist more in the states where plaintiffs have lost the state court litigations, but they do persist in all of the states. And part of the reason is nobody's aware of this complicated scenario that there's no right to education under the federal Constitution. There may be in different state constitutions, depending what state you live on. But if we're going to have a solid legal basis for asserting equity and rights in education, really it has to come from the federal level. If there's a ruling from the Supreme Court that says there's a right to education, that is going to resound solidly and loudly throughout the country. That's going to make a huge impact. I'm always amazed when I go and give speeches in New York where we won this big victory and there is a right to education, and nobody knows anything about it. Very few people build on it. They don't use it as an organizing basis. They don't use it as leverage with the legislature in the way that they could. But if the U.S. Supreme Court speaks out on this issue, people are going to know it, and it's going to have a huge impact. So what's going on in this case that we brought in Rhode Island? What we did essentially was pick up on what we think was a clear opening that the Supreme Court left in Rodriguez. And Kimberly went over this very quickly, so let me hone in on it in a bit more detail. It was a 5-4 decision. The majority says there's no language in the Constitution, explicitly, implicitly, that talks about education. That was left to the states. Okay, that was what the 5-person majority said. But there were 4 dissenters, and those dissenters were very upset at the outcome of this case. Quite frankly, Rodriguez announced the real turn in the Supreme Court at that time from the Warren Court era, the liberal building of rights, to the more conservative approach that led to a pullback in desegregation, all kinds of other areas. Rodriguez was the announcement that change is coming, and this 5-4 majority took a turn that, quite frankly, most observers at the time did not expect. They expected the plaintiffs to win. So Thurgood Marshall, who, as all of you know, was the lead counsel for the plaintiffs in Brown v. Board of Education, was particularly upset. I think he knew that if we were going to get equal opportunity, if we were going to get meaningful desegregation, we also had to have fair and equal resources. So he wrote a stinging dissent, and the essence of it for our present purposes is, he said, okay, there's not a word about education in the US Constitution, but there is a 15th Amendment that says every citizen has a right to vote. There is a First Amendment that says every person has a right to free exercise of speech, to participate in government and all. And Marshall went on, nobody can exercise those fundamental constitutional rights without some basic level of education. Now, the majority was clearly disturbed about this, and Justice Powell, who wrote the majority decision, clearly said, we don't dispute those propositions, that some basic level is necessary. But as Kimberly indicated, they indicated that the plaintiffs in that case had really not presented convincing evidence on those points. They were concerned with the fiscal inequities. They didn't present the case that said, in order to exercise the right to vote, you need such and such level of education. So the court essentially said, well, it may be that you need some basic quantum of education to exercise these constitutional rights, but the plaintiffs haven't established what that might be. We essentially leave this issue for another day. So we're essentially saying that other day has now come. And some people ask me, why did you pick Rhode Island to bring this case? Quite frankly, our case is built on the fact that you do need a solid basic education to be an intelligent voter, to be a participant in our democracy, and that students in many states, in many schools, are not getting that level of education. I think civic education has been a low priority, at least for the last 50 years throughout the country. There are all kinds of reasons about this. And if we're plugging books, I wrote a book last year called Flunking Democracy that lays all this out, why there's been a decline in emphasis on civic values and civic issues and civic knowledge. But the bottom line is, this is a disaster area. And it's quite interesting that Chief Justice Roberts noted this, more than noted this. He articulated beautifully what the problem is in his State of the Federal Courts message at the end of last year, barely a month ago. His whole message to the courts was, it's important for us to emphasize constitutional values. Civic education is being neglected in our schools. It's absolutely necessary for students to learn these constitutional values because they don't come without education. And then he went on to say that many federal judges are holding seminars for high school students, inviting them into the courthouse. More courts should be doing that. But he really focused in on the problem that schools aren't doing enough and courts can do more. Well, we're giving him a case that will really spell out what needs to be done, how it can be done by the schools, and what role the federal court should play. We could have brought this case in any of the 50 states because all of them are not where they should be on teaching these civic values and civic knowledge and civic skills. We chose Rhode Island for a number of reasons. They have a particularly bad education system, quite frankly, especially in civics. And it's also one of the states where plaintiffs have lost in the state court twice. So they've got no remedy to go to state court. And the case was filed about a year ago. We immediately were served with 2 motions to dismiss from 2 groups of the defendants. We've had intensive briefing on this, and we had our oral argument before the Chief Judge of the Rhode Island District Court, William Smith, last month. So we're expecting a decision this spring, and we are asking that that issue that was left open by Rodriguez be answered at the district court level. We've asked the judge to say that there is a right to some basic quantum of education in order to be a capable citizen, and that we should be allowed to go to trial to establish what that basic level is and to prove that students in Rhode Island in particular are not reaching it. We expect if we win that there will be an appeal to the First Circuit, and that whoever doesn't prevail there will bring the case to the Supreme Court. As you know, the court sets its own agenda. They have to decide whether they want to take such a case or not. But we were very impressed with Chief Justice Roberts' concern for this issue and his statement about how many other federal courts throughout the country are concerned about this issue. So we are cautiously optimistic that these arguments will at least be considered. If I have 2 more minutes, just to mention something else, because I think the lawyers, especially listening to this, should be aware, there's another case pending in the 6th Circuit coming out of Detroit that's making similar arguments that Rodriguez has to be reopened for this claim of a right to education based on skills and knowledge you need for capable citizenship. In that case, the plaintiffs asserted that the Detroit school system is so bad that students who go through the system, a vast majority of them turn out to be functionally illiterate. So they're pushing for a right that's based on, at least, if nothing else, you have to know how to read and write in order to vote, in order to exercise First Amendment freedoms. In our case, we're pushing for a much more robust definition. We define the skills and knowledge needed to be an effective citizen, really at the level of a basic, substantial quality education. So both of these arguments are being made. The Detroit case, they lost on a motion to dismiss. It's now on appeal in the 6th Circuit. So you can follow both these cases and see if we make progress, and if indeed the federal courts are going to reconsider the issue, and we hope declare there is a right to education under the U.S. Constitution.
Thank you. Thank you so much. And that case is Cook versus Raimondo in the District Court for Rhode Island. Thank you to all of our panelists. I hope you can all join me in virtually thanking our panelists who provided such a great overview of the tie of education to meaningful civic participation. Thank you to Peter, who really laid the foundation for today's conversation, who highlighted the ways that our school system can at times reproduce an unlevel playing field, and really how we can make an effort to have our schools help to create a society that's inclusive, tolerant, and cooperative. Thank you to Lisa, who really provided some strong, compelling examples of how these inequalities play out in the lives of students, including through discriminatory discipline practices. And it's really encouraging to hear these litigation efforts and the movement lawyering that's not just removed in our courts, but is really involving community members and those who are impacted. And thank you to Kimberly, who gave us a great overview of the legacy of Rodriguez, how it's still impacting our educational landscape, including by significant funding disparities between our higher wealth and lower wealth districts. And again, the implications of this, the consequences for students and their ability to participate in our society. And thank you to Michael Rebell for that great summary and the status as well of some current cases. So we do have one question, and if you have a question, if you can please note it in on your control panel, there is a option to note your question. The first question is for Michael Rebell and Kimberly Robinson. And they ask, the Supreme Court seems unlikely to make a progressive ruling on this topic, and that's the topic of the federal right to education. Do you see any hope to enshrine a right to education via legislation or a constitutional amendment?
Yes, so that is actually a topic that I addressed, and then there's a chapter about the Southern Education Foundation about a constitutional amendment on education. So we explore a variety of avenues for a federal right to education. The Supreme Court is not the only one. Congress certainly has the authority to recognize a federal right to education. And then certainly a constitutional amendment is something that could be debated among the states and enacted. So those are particularly legislation seems more possible given the current constitution of the court, although I don't foreclose the possibility that the Supreme Court could recognize that there is some right to a federal right to education. I do think, however, we should draw some lessons from No Child Left Behind and the dramatic increase in the federal role that we had under that. What I propose in the book is a much more incremental increase in the federal role in education than the one we saw under No Child Left Behind, that would test out in the laboratory of the states different approaches to the federal right to education before permanent legislation would ultimately enact one.
So I'll just quickly state that Kimberly and I have been having conversations, differences you might say, over the years about what the most effective way to establish this right is. And as the questionnaire put it, some people are skeptical whether the Supreme Court, as presently constituted, would really entertain this argument. I expressed some skepticism whether the Congress, as it's presently constituted, would go along the path that Kimberly's suggesting, or certainly that the states would be prepared to adopt a constitutional amendment. One reason that I've plowed ahead with this federal litigation is that because the focus is on civic capacity, we think this is a nonpartisan issue, and we're trying to present it that way. This is not a progressive issue or a traditionalist issue. If there's one thing that people across the spectrum of political views agree on, it's that we need to train our citizens, our young people, to understand democracy and to help maintain the democracy. We may have different notions of what values should be taught, what priorities should be established on history and how you discuss civics. But the basic question of making this a priority in the schools, the general area, I think there's broad agreement on. And, you know, I'll just share with you one question the federal judge asked me when we had our oral argument. He said, you know, if we grant your petition and say there's a right, what does this mean for the federal courts? Are we going to get the kind of resistance we got in desegregation and embroil the courts in all these policy issues? And I had a very quick answer. I had a longer answer. I'll give you the quick answer. I said, Your Honor, I think I can assure you that no governor is going to stand in front of the doors of any high schools in the United States to block people who want to go in and improve civic education. So it is a very different issue. I think it's going to be seen as a very different issue by people at large, and that's why we're plowing ahead with this case.
Great. And so we do have actually quite a few more wonderful questions. There are a couple that seem to address the same issue, so I will try to combine them. This is for everyone, but I'm thinking particularly, Lisa, just given your background working on international human rights issues. The question is, first of all, thanking everyone for great presentations. But they're asking, I'm wondering if anyone can speak to the possibility of utilizing international conventions and understandings of basic educational rights in these various efforts to establish commitment to fundamental educational rights and or adhering to international standards. There's one follow-up to that. Do other countries provide a constitutional right to education? Is there any value or trends found in the international law area that are insightful?
Yeah, I'm
That's a
happy to
lot,
take.
Janelle.
Yeah, I'm happy to address the first part of the question. Regarding the second part, I know that there are countries that have, many other countries that have a federal right to education. I don't have at my fingertips the names of those countries, but a lot of the countries in Northern Europe do have a fundamental right to education. But regarding the utility of international conventions and international standards in this effort to expand the fundamental right and to deploy a fundamental right federally, I think that's a very good instinct. I do think in the past the United States Supreme Court has sometimes looked to international conventions when discussing these major policy issues. I mean, off the top of my head, the Furman case in 1972, where the court essentially struck down all death penalty schemes, that only lasted temporarily. But in that case, the court did look at international conventions around the death penalty. And they were compelled by the fact that so many countries internationally had ended the death penalty. And so that compelled the Supreme Court at the time to really look carefully at our death penalty scheme and to suspend it until it could be improved. But the point being, I do think that international conventions can be utilized creatively in this sort of litigation effort. More importantly, I think that it's important to organize on the ground socially around international conventions, because I think that most citizens and people find that they're interested in what's going on globally, and they also find the evidence that other countries have these rights and have signed on often as United Nations to these fundamental rights. Ordinary citizens find this very compelling, and they're like, well, we're supposed to be a leader in this geographic space. How come we are not keeping up with the progress and the progressivism that we're seeing in these other countries? So I think that I think that international conventions around the fundamental right to education are a great organizing tool. And I am always an advocate of on-the-ground advocacy, creating the political will among the citizenry, and so that we can move our litigation forward in tandem with on-the-ground organizing campaigns.
You know, Janelle, if I could just pipe in, because I have done a lot of work on international aspects of education law, and as Lisa was indicating, there is an international covenant on economic and social rights that calls for a right to education very explicitly, and the vast majority of advanced countries, of all countries, have adopted it. The U.S. stands out by the fact that we have not signed on to that. On the basis of that covenant, many countries, just about every South American country, has strong language in their constitution based on the international covenant. Most European countries do. But the interesting thing, and the reason why I've been asked to explain our state cases, those are rarely enforced, and they're considered aspirational in most of the South American countries. On the other hand, there are countries like India and South Africa that take very seriously the language in their constitutions and do have very strong precedents on implementing what that could mean. But in general, the UN bodies that I've been asked to speak to and all, they want to know how the courts handle these complicated questions of relations with legislatures. Can a court order more money, et cetera, et cetera? And they think our state cases, quite frankly, have gone further than most countries have gone, even though they've got stronger language. So it's a very interesting back and forth on how this international scene works.
You know, I'll just say a few words. I mean, I think,
Yes,
you know, I did a book about the educational rights of children. So I did a summary of all these, as Michael says, and Lisa says, there actually is a long line of covenants, Millennial Report 2000 and so forth that had a free education. I think, though, I think there's value in the states, the way we do it now, but it also creates problematics across the board because it depends on what state you live in, depends what region of the state you live in. It's a very complex system, and I think we have to acknowledge that honestly, because there are huge disparities between states, regions, parts of states. And I know Michael and Kimberly and Lisa have been involved in this, but when you get on the ground, you wonder how this is going to really play out and what this means in the lives of kids. We were part of LPI with West Ed was part of putting together an educational plan in North Carolina in response to the Leandra decision that was just recently released by Judge Lee in North Carolina. And I'm hopeful that our plan will be implemented, but it will cost a lot of money. And I'm very curious. I'm going back to North Carolina. I'm very curious to see how this actually plays out in real time, over time in North Carolina as an example, because there are a lot of problematics, even at the district level. There are a lot of problematics about how resources are shared. And that has to do with the superintendent and making decisions at a very local level. There's also a movement to separate, to succeed in those counties around the country that are have an African American or a minority population and a white population. Not to be just be pretty straightforward about it. White populations are attempting to succeed essentially from those school districts and establish their own. So while I think the courts can do a great deal, there's a very large political problem that frames this that needs, there's no resolution to it that I can think of off the top of my head in a simple way, but it's definitely shaping the way this all plays out in time.
thank you all. And we're receiving some really great questions, and we will try to get to as many as we can. One overarching question, isn't it also necessary to teach our students what democracy is not? The rise of autocratic regimes is something worth noting, how they pervert what democracy is. Anyone want to speak to that?
Well, you know, Peter had made an allusion to some of the recent data that talks about the change in understanding of democracy among young people. Along those lines, I was really most struck by something called the World Values Survey that asked a very interesting question of people of different ages. And the question was, do you consider democracy to be an essential system of government? Is democracy essential for you in your life? And among people born since 1980, the answer to that was 30% considered democracy essential. When they asked the same question to the generation born before World War II, over 75% answered that it was essential. So it's a very graphic indication of where our understanding and appreciation for basic democratic values has declined over the last 50 years, as I put it. And I don't know whether the best pedagogical approach is to talk about the evils of authoritarianism or the virtues of democracy. But from my point of view, raising this to a higher level of educational priority is the main thing. And I have confidence that our teachers can develop the best pedagogical ways to make those points and shore up those democratic values.
great. A couple more connected questions, and this can be for anyone to address. What would be the limit on a federal right to education? What would this right actually entail? Is it the right to high school education, the right to access any level of publicly funded education? How would the right actually be defined? Or
So
what is
that's
a
a
baseline guarantee? I'm sorry, Kimberly.
Yeah, so that's a question that is taken up in part 3 of the book I just published, and there's debate about what a federal right to education should include. So really, what it includes depends on ultimately the aim of the right. So if the aim is to ensure that we have students who are prepared to be both engaged citizens and productive members of the economy, then you tailor the skills and opportunities that students would receive and have a right to receive to that aim. Rachel Moran in the book talks about an interest in having an ability to compete successfully with your peers, or at least effectively. And so that would help to level some of the current disparities in education opportunity to ensure that those who are sort of left behind by the education system now receive the additional opportunities that they need to compete effectively with their peers. So much of it will depend on the aim of the right itself, and that is something that most people will agree that we need to have educated citizens, and so that part of it, in terms of how it relates to our current topic, is really not that contested. However, sort of the level of detail in which the right is defined, people do substantially disagree about. So you could define the right as the right to an array of resources, such as high quality teachers, an effective, full cadre of courses for a high school diploma, effective, administrators to oversee that education. So it really varies based on sort of what the ultimate aim is, and then how that aim is translated into actual resources and opportunity. So there is debate around that question.
Yeah. I just think that what Kimberly was saying in her everybody was saying, everybody on the panel was saying, without adequate resources, and sometimes more than just adequate resources, rights might be good on paper, might look good on paper, but what really happens? And I think that was why it was great to tie. I just want to say both the presentation here to tie these rights with actual finance, with actual resources, because that's what it's going to take. And equity requires a great deal more investment than just, sort of formalized equality. And it's definitely a income issue, a wealth issue, a race issue, a regional issue. I noticed in that chart that Utah was, it was progressive, but it actually had a very low per pupil expenditure. I don't know quite what that means, but I think that I think we need models that are a little bit more sophisticated in terms of how this all really plays out in real time at the local level.
I would just, I'm sorry. I was going to say, my understanding of how you bring about meaningful social reform, not just abstract legal decisions, is that a right declared by a court gives great leverage to social movements, and Lisa was bringing this out. And I think we're aiming to get the U.S. Supreme Court to make a major statement that would galvanize all kinds of interest and would give opportunities to all kinds of advocates in each state to then work to define it, to get the resources and all the rest. We're not asking for some very strict federal injunction that lays out what kind of teachers you should have or what class sizes. We would say use this as an opening to really change thinking throughout the country about how important these things are. And then we leave it to all of those many, many thousands and millions of people who are concerned about this and well-organized groups to go out and fight the good fight and have the Supreme Court behind you.
I agree, Mike.
Okay. In our last few minutes, I'm going to combine a couple of other questions. One is from a young lawyer who, with an education background, who is asking for what would your advice be for someone who's interested in doing this type of work, this type of litigation? What types of organizations or firms should we be looking at? And then I think a great closing would be a question that's more directed towards Peter. If you could expound on what a day or week in a school might look like for students, for teachers, for parents, in which democracy is really in its bones. So why don't we start with the more practical career advice, and then end with kind of this vision of what are we imagining for education where we're really preparing students to participate in democracy.
Well, on the practical level, I think in every state you're going to find numerous organizations that are interested in education reform, whether it's a branch of the NAACP, whether it's the Education Law Center in New Jersey and Pennsylvania. So a young lawyer is interested, check out who's doing education advocacy, see if they have jobs. Unfortunately, there aren't as many jobs as there should be because these groups are funded and they need more support, but that's where to look. Anyway, I'm interested in hearing what Peter has to say also.
Yeah, so I'll just add before Peter jumps in that so you can look not only to nonprofits, but there are states who are state governments who are doing some very progressive things in education where you can help to shape and inform what they're doing. There are also organizations, as Michael mentioned, like the Legal Defense Fund, who does exceptional work in education. In addition, the Office of Civil Rights at the U.S. Department of Education has always been a leader on these issues. And even though, currently there's a more conservative president in office, you will see if you are within the Office of Civil Rights that there is still a core group of attorneys who are very focused on ensuring that the nation's civil rights laws are upheld. And so that is, so government is certainly an avenue that I point my students to for getting involved in these important issues. And I do want to just add one thing before Peter jumps in, which is, in addition to sort of these issues for democracy, the other issues that are related to this include sort of looking at education, not just for students K-12 and in higher education, but my husband has written a book about education for liberation, which education for prisoners as well, many of whom have been neglected in our K-12 systems. And so I think we should think broadly and expansively about these issues, about who needs and should receive an excellent education.
Well, I'll try to answer your question and give you a directional, maybe part of the way I can do that is give you some sense of this. There is a really strong line of progressive educators in the United States that have taken on this issue of democracy in the schools as well as a kind of the social relationships. Deborah Meyer and others. I would, we can't summarize this in 3 minutes on this, but if you look if you look up John Dewey, if you look up Deborah Meyer, and I will put a little plug in for Learning Policy Institute, and Linda, who is the CEO and founder of LPI, has probably written as much or more than anybody else about, and in a very practical way and a very empirical way about the value of whether you call it progressive education or not, but whatever education that really serves all kids. So there is a long line of folks and that do that. On a personal level, I'll just say that here's how I see it. I did a lot of research in New York and the Bronx, and the way I would love to see it is to have something in this little book that I mentioned to you before, which is a community living and learning center. So you don't begin with a school, you begin with a learning center, which invites all people into that center. It's for parents and grandparents as well and community members. It offers a wide range of learning opportunities. It's based in the community. There's a community council that actually has a great deal to do with setting the policies. I assume in my little book that there's adequate funding before I even really got involved in the research. It's a topic that I think the federal government should be involved in, to be quite frankly. I know there's all the laws here, but I don't really see how you're going to get equity in some of these areas without that kind of emphasis. So I called it the Bolivar Center because the high degree of folks from the countries in South America, and it's a hub of a learning center. It includes 15 square blocks in each direction, and it has 60 square blocks in which all of these becomes a hub, and there's schools within it. I can't go into details. Jeffrey Canada has done some really interesting work in the Harlem's Children's Zone, which I would advise you to look at. It's kind of, he's doing this sort of this idea that I had. He's done a great deal of this. So if there are people out there who have really recognized the need to have this grassroots, high quality, caring, consistent education. And this goes back to the 19th century. One of the more interesting groups in New York City is the Family AIDS, the Children's AIDS Society. And they don't do a lot. They don't have a lot of money, but they go to schools. They offer basic health for people. It makes a huge difference. So all I can say to you is that there are some visionaries out there. And if you, I don't know how quite this works, but if you email me or you get in touch with me, I'd be happy to give you more information, who have done this and are committed to it. And they have made a difference. There's good data around this too. It isn't just an aspirational goal. We know that it makes a huge difference in kids' lives. So.
Thank you. And thank you again to all of our panelists. And again, when we post a recording of the website, we will also make handouts available. And I know someone just posted a question asking if the names that Peter just mentioned could be provided, and we'll follow up with detailed information, and we'll also follow up with contact information for our panelists. And again, thank you so much, everyone who joined us this afternoon. I want to close by just, noting the great work of the Civil Rights and Social Justice section. The section and its members have, for more than 5 decades, worked on behalf of hundreds of people and addressed a lot of issues ranging from civil rights, civil liberties, and international human rights. Today, the section continues to promote policies affecting religious freedom, LGBTQ rights, gender equity, and other significant civil rights issues. So please consider making a donation, and you can see on this closing page the link to do that. Your gift will help make our efforts possible for decades to come, when some of the young lawyers who apply for those jobs and are doing this work can continue this and have your support. So again, thank you so much for joining today's discussion. I'm sorry, who would think that we would run out of time for an hour and a half, but thank you so much for your time, and we will follow up with handouts and information.
Thank you, Janelle.
Thank you.
Thank you all. Have a good afternoon.